Great news for parents. Both partners will be eligible now for maternity or rather parental leave. Now, the groundbreaking judgment was made in the High Court in Johannesburg last week. And for more on this, let's bring in Leila Moosa from Cliffe Dekker Hofmeyr. Leila, thank you so much for joining us this morning. Now, according to the law, the mother is entitled to 4 consecutive months maternity leave, not necessarily paid, with the father also allowed 10 working days. How does this ruling last week change this now?
Yeah, thanks very much, Melissa. So the ruling that we saw last week essentially declared it to be unfairly discriminatory in relation to that maternity leave benefit that relates to mothers only who give birth to the children. So there we know that birthing mothers were allowed to have 4 months of maternity leave off, with the fathers then potentially having that 10 days of parental leave. And essentially what the court said was that if we compare this to the benefits that we see that align with adoptive parents and commissioning parents of a surrogate motherhood agreement, for example, or those who are non-birthing, in other words, there is a discrepancy there in terms of the time, because they're only permitted for one of the parents, being the primary caregiver, 10 weeks, and the other the 10 days of what was our parental leave benefit. So the court looked at that and said, well, what this does is, number one, unfairly discriminates between mothers and fathers, and then number two, it unfairly discriminates between one set of parents and the other on the basis of whether, one, the children were born from the mother, two, they were conceived by surrogacy, or three, they were adopted.
Now, Leila, practically, how will it work? Can a mom and a dad take the time together? Maybe like the critical first month, just getting used to the new baby?
Sure. So I think there, Melissa, the starting point is to think about, well, why did the court make this ruling? And the reason for that was while the court recognized that in relation to a birthing mother, there's, of course, a physiological element that needs to occur, right? Because one is actually giving birth and the body needs to heal, etc. But the court said that for the purposes of these questions, the main focus is really, well, it's the time to nurture the child. And the fact of the matter is that whether or not one had given birth permitted an additional 6 weeks, which, yes, the mother was recovering, but also had to nurture the child in parallel. So a child born of their mother would get an additional 6 weeks of nurturing during that what was the maternity leave period. Now, the important thing there is, if it's about nurturing the child, it's the fact that we need that 4-month period, and now there's the 4 month of parental leave, whether or not there's a birthing parent, an adoptive parent, or commissioning parent. Now, with this in mind, the court then, when it made the ruling, said that the reading in of the provision would be as follows, that for the time period, of course, Parliament still needs to, they have their 2-year period to make the necessary amendments to legislation, if, of course, this ruling is confirmed by the Constitutional Court. But what the court said in reading in was that it would be that either one or the other parent can take the whole period, or the parents could take turns taking the leave, and both of their employers need to be notified of that. So I think in the taking turns, it's contemplated that there's the full month for the nurturing of the child. That is the purpose.
Now, if we look at the challenges, like you said now, both employers have to be notified. But just another practical thing is there a lot of people who can take unpaid maternity leave? Because unfortunately, most maternity leave, or parental leave in this case, in South Africa is unpaid. Some employers do pay a little bit each month, but it's still a very big financial decision as well.
Of course. So I think what you've touched on there is critical and dealt with within the judgment, and that's the policy impact of what we see in terms of our unemployment insurance. So the starting point, as you say, is that what used to be our maternity leave benefit, that 4 months, was a period that was technically unpaid by the employer, but during which, if one is employed and a UIF contributor, one as the person claiming the maternity leave benefit could then claim from the unemployment insurance fund for that period. So what the court has recognized in the judgment is that in the event that now what used to be this 4-month period referred to as maternity leave, we now have a parental leave for 4 months, irrespective of whether birthing, whether by adoption, or whether by a surrogate motherhood agreement. That there would be that 4-month period. And the court has recognized that this means that we're going to have to look at policy in terms of what happens in terms of the UIF and how that potential parental benefit may be claimed and what that may mean. So yes, there are those financial implications. There are also policy implications on what that would mean from a UIF perspective.
Thank you so much for your time this morning. That was Leila Moosa from Cliffe Dekker Hofmeyr.